Hello, everyone, and welcome to today's edition of Nation Watch. It's Sunday, 30th March 2025. Closer and closer we creep towards elections 2025. And as we close the gap, the elections, we are seeing more and more evidence of persecution of opponents of the People's Progressive Party. The official state agencies seem to be the chosen path towards the persecution, in some cases prosecution, of forces who oppose the People's Progressive Party. On Thursday last, former Minister of Finance, Mr. Winston Jordan, was served with a document titled Summons to Defendant upon Complaint or Information. So Mr. Winston Jordan was served with a summons to appear in court. This summons is returnable for Monday, 31st day of March 2025. We will show you the actual summons there on the screen. You will detect that Mr. Jordan has been charged with an offense similar to the one that he was previously charged with in 2021. Now, misconduct in public office is what this is essentially. The state of Guyana, I'm quoting from the document, the state of Guyana, let's see what it says here. That he willfully misconducted himself by acting recklessly when he signed vesting order number 69 of 2020. This has to do with the state's disposal of a property. And as we all know, it was determined some time ago that cabinet decisions are taken collectively, and therefore there are some levels of protection in that regard. But Mr. Jordan is being persecuted once again by the state, and we will show you evidence of the earlier matter, the 2021 matter, where he was similarly charged. That matter was dismissed by the chief magistrate, and I believe that there were some other actors of another department of the state, resulting in the matter going towards finding its way in the High Court, whereupon it was again dismissed. So in the face of two dismissals of a similar charge, this has got to be nothing less than an absolute case of persecution. We of the People's National Congress Reform stand with Mr. Winston Jordan as he faces this malicious charge, which in my view, constitutes persecution of the man himself, the man having done a sterling job for the people of this country. And we're going to move on to some other very interesting bits of information before we get into our program proper. Ladies and gentlemen, you will recall that not so long ago, the people of the villages of the North Rupununi objected to mining taking place in Arnaputa NDC. Arnaputa is in the Anai district, the general area. It is now a Labour Democratic Council, having been given status, I believe, in 2018 by the APNU AFC administration. Interestingly, here's the story. A mining permit was given to a Brazilian investor by the Neighborhood Democratic Council's chairman, not necessarily the council, but by the chairman. And what makes this very interesting is that the Minister of Marine Affairs, who has absolutely no jurisdiction over Neighborhood Democratic Councils, found herself in the middle of the negotiation and signing according to the information we received. In fact, there's a public photograph of the Minister of Marine Affairs and her legal assistant witnessing the signing of the agreement. The villages of the North Rupununi, spearheaded by the chair of the North Rupununi District Development Board and two showers of all of the villages, made representation against the mining activity, citing reasons having to do with culture, customs, practices of the indigenous peoples, and the interest of preservation of the environment, whereupon the government, represented by its Minister of Natural Resources, had no choice but to suspend the mining license given to the investor. Here's what's interesting about this. Before the agreement was signed, the investor had already started to do work in Arnaputa. 2 reservoirs were established, a road was built, and camps were set up and so on. Money was expended. Lots of money was expended before the signing of the agreement. That in itself tells a story. The chairman of the Neighborhood Democratic Council, who really never even had a bicycle, no sports, I am told, 3 spanking new motorcycles, has extended or is in the process of extending our house, and somehow miraculously secured enough resources to start land preparation in a major area of land. She's going into farming in a big way. The expansion of the chairman's operations and the acquisition of these motorcycles and the alleged acquisition of 2 additional motor vehicles, which are still in the city of Georgetown, coincide with the signing of the mining agreement. The question of whether they're related is one which may come out in time. We understand that the vehicles allegedly bought and in Georgetown were gifts from the miner. We understand that it is being alleged that the miner is withholding the release of those 2 vehicles because of the suspension of the mining agreement. All of these situations, all of these developments, only time will reveal the truth. Over in Mabaruma in Region 1, there's a team at work in the Regional Administrative Office. This team is specifically charged with receiving applications for birth certificates, for processing those applications, for sending them down to the General Registrar's Office in Georgetown, and for receiving the finished documents and distributing them to the applicants once issued by the General Registrar's Office. The report we received is that this team is superintended directly by the regional chairman. The regional chairman must tell us whether he is in fact directly responsible for the functions of this department. The person who leads the work of the department is Megan Cyrus. Ms. Cyrus became very important to a police investigation recently when it is alleged that a Venezuelan national was found with a document purporting to be a Guyana birth certificate, which upon examination was allegedly found to be a forged instrument. Ms. Cyrus, we understand, was caused to assist the police in the course of an investigation into this document, and it resulted in the home of a person in Bunbury being searched by the police. This person is a kind-hearted elderly woman who accepted Ms. Cyrus in her home because of some difficulties she was facing in hers. What is most interesting in this matter is that we understand that Ms. Cyrus recently cohabited with a top regional official, a high-ranking regional administrative official, and they live near to the GT&T facility up there in Mabaruma. So we anticipate that nothing will come of this matter. A, because of whom the social partner of this person is, and who's in charge of the actual operation and to whom she reports. But this is evidence coming to light that there is a grand scheme of forging birth certificates and placing them in the hands of, in this case, non-nationals. Last Sunday, I reported that it was discovered in the northern state of Roraima in Brazil, in the municipality of Bonfim last year, that there was in fact a printing operation which became the subject of state police investigations in Bonfim and unearthed evidence of forged documents being prepared at that place, among which documents were reportedly Guyana birth certificates. I bring this to the attention of the public because I anticipate that more of the same will eventually surface, even as the People's Progressive Party continues to persecute its political opponents. Permit me now, ladies and gentlemen, to introduce my guest, seasoned, long-serving Commissioner of the Guyana Elections Commission, Mr. Vincent Alexander AA, the longest-serving commissioner at GCOM, and the man who was instrumental in saving at least 2 elections in this country from being stolen. Mr. Alexander, welcome to Nation Watch.
Thank you very much, and good day to your viewers.
Last Sunday, ladies and gentlemen, we discussed with Dr. Dexter Todd, attorney for Carol Smith Joseph, chief scrutineer of the People's National Congress Reform, some developments in a case that is before the court. Ms. Carol Smith Joseph, through her attorney, Dr. Dexter Todd, asked the court for an interpretation of an amendment of 2022, an amendment that changed residence, which was understood to mean verified place of residence of a registered voter, to address claimed, which means that when you register now, you state an address on the registration application, and that, as far as GCOM officials are now concerned, is enough for you to go on the voters list, well, in the National Register of Registrants in the first place, and eventually to the official list of electors, without verifying that as the applicant for registration, you reside at this particular address. So that's what that court proceeding seeks to secure, an interpretation of that amendment. We are at a place where the ruling of the Chief Justice was deferred from last Friday to either the 3rd or 4th, I'm not sure, of the new month. Mr. Alexander, why was it necessary in the first place to approach the court as Ms. Smith-Joseph did in this particular instance?
Thank you very much, Mervyn. Mervyn, allow me to comment on the matters you raised
Certainly.
in the inception.
Certainly.
And the first one I want to comment on is this question of birth certificates. You raised the matter from the standpoint of a forged birth certificate.
Yeah.
But I would like to remind the public that there has been legislative amendment in Guyana that makes it possible for someone to get a Guyanese birth certificate based on an affidavit signed by a Tushaw or some senior person indicating that this person is known to have been born in Guyana. And on that basis, a birth certificate is granted. I'm raising that because the fact of the matter, in a country where there is so much corruption, we have introduced a law that makes it highly possible for birth certificates to be corruptly assigned to persons.
Officially too.
Officially assigned to persons.
So there's no real need for forgery.
So there's really no need for forgery on one hand. Of course, they will tell you that there's an affidavit and the person could be brought before the court and all of that. But the fact of the matter is, we have introduced a system that makes it very, very easy for persons to acquire birth certificates who were not born in Guyana. And by the acquisition of that birth certificate, the person then finds himself or herself onto our National Register of Registrants and eventually onto the voters' roll. So we have a situation where, in fact, our voters' roll could well be padded by bringing people into Guyana, granting them birth certificates on the pretext that they were born here and somebody has signed off on that, and in that way influence our voters' roll and eventually the outcome of our elections. So that's the first observation I want to make. The second observation I want to make is about the charge against former Minister Jordan. Misconduct in public office. We seem to be very choicy in how these charges are laid. I recall in 2011, that there's Chief Elections Officer brought before the Elections Commission a false result, a false declaration. And he was not charged with misconduct in public office.
Or at all.
Not charged at all. And in fact, what happened, the PPP simply said that he had made an error, which he himself did not admit. He argued in the commission that he was right. We managed to prove him wrong. He was not charged. And after he demitted office at the end of his contract, he became, I'm told, an employee of at Freedom House and/or Office of the President. So we see where there's a very discriminatory way in which this question of people being charged for misconduct in public office is applied. And I could comment also on the case of Minister Westford, where she was charged. She was not charged with misconduct in public office. It was unequivocal, even when the case was heard, that these monies had not been accounted for, and in fact, that the monies had not been spent in the manner in which it should have been spent, but for some technical reason, in terms of the type of charge brought, she got off. But certainly that was also an instance of misconduct in public office. So this seemed to be a weapon. This charge was weaponized to attack some specific people. Now getting to the actual question which you asked.
Some more decay there in the democratic system.
Yes. The question which you asked, the public should know that in subsequent to the elections of 2020, the government claimed that they were engaged in a reform of the Representation of the People's Act and the National Registration Act, and that reform was intended to strengthen the systems in relation to registration and elections. And more recently, Attorney General Nandalal claimed that the specific reform we will talk about was intended to bring the laws in line with the Constitution. And what law is that we're talking about specifically? A change has been made in the National Registration Act, which now allows for someone to be registered without the previous procedure of going to the person's residence to verify that the person does in fact reside there being done. Someone now simply has to, in the registration process, submit an address, and once that address is said to be an address that does exist, the address exists, then that person is registered as if he or she resides at that address. So that is the amendment that has been made, among others. The Carol Joseph, the People's National Congress Reform, there's the APNU, Chief Scrutineer, has brought an action on this matter. And what's the nature of the action? She has gone to the court to complain that this amendment breaches the requirements of our electoral system in terms of local government elections, which specifies that a person must be known to reside in a particular place to be registered, and that the way in which this is done is to verify the person's place of residence by going to see that the person does in fact reside there. And that this provision is also applicable to regional elections, as well as is contended should be applicable to constituency elections, because you know at the national elections, we have 10 constituencies. And so what Carol Joseph is arguing is that to remove the requirement for someone to be verified at the place of residence is in fact allowing someone who may not be in fact resident to be registered in a place where he or she is not resident, and consequentially to vote in an election, particularly a local election or a regional election, and in constituent elections, in a place where he or she should not be voting. And let me be specific of that. The issue is not that the person should not vote, but the person should not be voting in a place where he or she is not resident. And why is there that contention? That contention is there because over time we've developed a system of democracy which seeks to relate our voters to the people for whom they are voting. Hence, at the local government level, persons must be residing in the local area to vote for their councillors. And in those local areas, more specifically, they must be residing in a constituency to vote for the person, the councillor who's going to represent that constituency. Similar, at the regional level, persons should be residing in the local area to vote for the councillors of the Regional Democratic Council. And as I said, the argument is that in terms of constituencies, persons should be residing in the constituency, because this is a part of what has evolved in terms of our democratic system, that there should be a relationship between the voter and the elected person, because the elected person is elected as a representative of a community of voters. So how do you allow someone whom you cannot verify is residing in that area to be counted in the community of voters who determine that representative, in a circumstance where if the person is not from that community of voters, then the person may be influencing who becomes the councillor, not having a right to do so. And this is critical because we have the instance in Region 8, where in one election, the difference between the two parties was one vote. And therefore, in any circumstance where you allow someone in who is not verified and who in fact does not reside there, it can have an impact on the outcome of the elections, as demonstrated in the case of Region 8. Now, there's this argument being put forward by the Attorney General and others, that Article 159 of the Constitution specifies that a person simply has to be a citizen and 18 years of age and to be allowed to vote anywhere, to be allowed to vote, and that anything that stops that person from voting is a breach of the person's right.
That couldn't be coming from the Attorney General.
It has come from the Attorney General. So let me clarify again that the issue is not about stopping someone from voting. The issue is about ensuring that people only vote where they are residing,
Constitutionally required to reside in,
where they
sir.
reside in, and where they are constitutionally required, and that 159 cannot simply be applied in a circumstance like that for a number of reasons. And one of the reasons would be this. In our constitution, in Article said 159, 159 2C reads as follows. No person shall vote at an election unless he or she is registered as an elector, and on the qualifying date, he or she is of the age 18 years or upward and either a citizen, a Commonwealth citizen. But the one I'm referring to here is C, which says satisfies such other qualifications as may be prescribed by or under any law. So that merely to say that no person shall vote as an elector unless he or she is registered as an elector, and to interpret that to be that the person is a citizen and 18 and that nothing else is applicable is to misrepresent what the law provides for, because the law under the same 159, which the Attorney General is using, says satisfies such other qualifications as may be prescribed by or under any law. So a qualification which says that you have to be registered and verified meets that requirement as prescribed for in the Constitution. But more than that, we're talking about a system of democracy. And one cannot simply use one provision to determine a matter. One has to use the Constitution in its entirety to see what other provisions are and what, in fact, are the underlying principles of our electoral and democratic system. And so in that regard, one has to make the observation that the principles and bases of the political and economic system, as provided for in our Constitution, Article 9 says the following: sovereignty belongs to the people. So that's the people at large. Who exercise it through their representatives. So the Constitution is saying that people exercise sovereignty through their representatives.
The thing that says duly elected representatives.
Through their representatives. And the democratic organs established by or under this Constitution. So what the Constitution is saying in Article 9 is that people exercise this sovereignty through the democratic organs established under the Constitution, and that in fact it is through their representatives and or the democratic organs. So that if somebody is not known or proven to be residing in a local democratic area, and that person is registered, then that person in fact is impinging on the community of that area who are registered and who are being represented by their local democratic organ established under the Constitution. Because the Constitution further goes on to say, local government by freely elected representatives. So the Constitution is clearly talking about people being elected as being representatives. And you cannot be a representative of someone who resides somewhere else and seeks to vote in your area, because, as it says, local government by freely elected representatives of the people is an integral part of the democratic organization. So, in terms of local government, there must be a freely elected representatives, and you cannot be a representative or you cannot be represented in the instance where you do not live in that area and are therefore affected by the decisions in that area. You should not be able to affect who are the representatives if you yourself do not reside there and is not affected by the decisions of those representatives. So we see in Article 13 of the Constitution, it goes on to say, the principal objective of the political system of the state is to establish an inclusionary democracy by providing increasing opportunities for the participation of citizens and their organizations in the management and decision-making processes. Citizens' involvement in the management and decision-making processes of the state, with particular emphasis on those areas of decision that directly affect their well-being. So the Constitution is making clear that people must be involved in determining representatives for organs that affect their well-being. And that in fact, the implication here is that if other people are involved, they may in fact lead to representatives who are not representative of the people because the people's vote have been devalued and others people's votes have determined the representatives of those people, clearly in breach of a democratic system. So what we see here is occurring is that there is an attempt by the People's Progressive Party in government to amend our laws, to in fact start to undo the architecture of our democratic system, start to undo a constitutionally provided for arrangement where our democratic system at the national level, at the regional level, and at the local level speaks to the elected bodies being representatives of the people coming from those specific areas. At the national level, a representative of any Guyanese voting because he's a citizen, age 18. A representative at the regional level of people who reside there and who are citizens and age 18. A representative at the local government level, meaning in this instance the national democratic, the regional democratic councils, of people who reside and are of age. And in that context, when one looks at the historical evolution of our system, we can see as of 2001, we introduced constituencies, and that those constituencies also speak to the question of assemblymen, parliamentarians who are specifically elected to represent the interests of those geographic constituencies, and by virtue of that, to represent the population of those constituencies. But here we have an attempt being made to impose a situation where people are not verified to be living there, but would be allowed to vote and therefore make a determination of who the representatives will be, when in fact they are not representing them because they don't live there, and they are also impacting the results and undervaluing the votes of the people who live there because they may well, by virtue of their votes, determine who the representatives will be, and the people who actually live there will not have had the opportunity to elect their representatives. Now, so this is what is happening in terms of the constitutional arrangements. And what is interesting in this regard is for us now to go back to see what is happening on the ground, to see how what the government is seeking to do in terms of our legislative architecture is playing out in their erosion of our democratic institutions on the ground.
Let's get to that in a minute. Fortunately, I can identify with the articles of the Constitution and the intent of those that you cited, because I recently did the Hoyt lecture, and a lot of what is happening here is based on an electoral system that flowed from the Desmond Hoyt-led legislation, the bit of legislation they think called the Local Democratic Organs Act. And that act is rooted in those articles that you cited and quoted, and I think two others. So I can relate to that. And I gather from all that you've said and all that I've read is that these are legislative interventions geared at preventing um, a shift of the demographics through paper manipulation. I am coming to a position in my mind now where I am seeing that the intention of the People's Progressive Party has to do with manipulating the demographic through the registration process to create an environment that is favorable to them. Since some of the parliamentary seats are up for grabs, for want of a better expression, through a geographic vote, a regional geographic vote, 25 seats. That's a lot of seats out of 65. Talk to us a little bit, Mr. Alexander, about what is actually happening in the proceedings. I gather from my readings and so on, what's happening is that the Attorney General, and what you've said too confirms that, seems to have no legal grounds to stand on to fight this issue. Because even the attorney for the Guyana Elections Commission has come around to accepting that there is an element of residency as a requirement for participating in certain of the elections that we have conducted at the same time, regional and general elections. And in that regard, I want to ask that we put up on the screen there, a statement of denial from the Chief Elections Officer, where he seeks to distance himself from his legal counsel on this matter. The legal counsel of the commission, not his legal counsel specifically. So let us look at this, and maybe you can help us understand what is happening as far as the submissions and arguments that are at your disposal are telling us about what's happening.
Now, let me just go back to something you said. I want to underline that in Guyana we have what is called a representative democracy. That's the democracy we have, a representative democracy. A representative democracy means that the people elect their representatives. Simple as that. And our constitution in Article 9 underlines that. And I repeat it. Sovereignty belongs to the people who exercise their sovereignty through their representatives. So that the people in parliament are supposed to be representatives of the people of Guyana. But the constitution goes on to say, and the democratic, through their representatives and the democratic organs. So what this constitution is also providing for is where sovereignty is exercised. At the national level, the population at large, once they are Guyanese, they vote for the parliament. And the population in specific geographical areas vote for the democratic organs. And here, democratic organs are the Regional Democratic Council and the Neighborhood Democratic Councils. So that to realize this representative nature of our democracy, the people who live there are the people who have to vote for their representatives. And to have people who do not live there vote is to have other people impose on the determination of who will be the representatives of people other than themselves. Because the Constitution clearly goes on to make the point that there is emphasis on those areas of decision-making that directly affect their well-being. So the decision-making by local democratic councils affect the well-being of those who live there. And to put in place a system that allows for registration of people who you can't verify live there, allows for people who do not live there, gives the probability of people who do not live there impacting
Yeah.
the elections.
And at the level of the local democratic organs, there is even a narrower residency requirement because each of the
And the
local democratic
constituency in the
areas
local
proclaim the
area, etc.
constituency. So
So that the AG is patently wrong to rely
I'm
on
shocked.
Article 159, which in itself, in C, goes on to say it's not just being resident, it's not just being a citizen, it's not just being 18, but other qualifications. And one cannot simply use one article to determine a matter. The Constitution has to be used in its totality. And in its totality, we have to refer to articles like Article 9, Article 12, Article 13, and I dare say there are other articles to which we have to refer, because in Article 173 also speak to this matter, and in Article 173, it is clearly articulated in that article, 173, it's clearly articulated clearly articulates I think I have a problem here with
Is it
this.
173 or is it 173?
173. 173, but I have a problem here with my document because it jumps from 172,
Or the
173.
order of page. Order of
There's
page.
some problem there with the order of the page. But let me say 173 specifies that someone who is being involved in elections for the Regional Democratic Council should be residing in the local area. 173 also specifies that. So this issue is reinforced by another provision of our Constitution, and that provision is 173. And let us be clear that in our Constitution, Articles 9, it is specified in our Constitution that in Article 39, it says the following: it is the duty of the Parliament, the government, the courts, and all other public agencies to be guided in the discharge of their functions by the principles set out in this chapter. And this chapter is referring to Chapter 1, of which Article 9 is an article. So that it is saying that whatever you do in terms of making laws should be guided by the principles in this article. And the principle here we've seen is clearly one of a system that is representative. And therefore, for all intents and purposes, to change the law, to remove a provision to ensure that people are in fact residing in an area and therefore are entitled to vote for their representative, or have the representative body make decisions in relation to a certain set of people, is in defiance of what the Constitution provides for, taken holistically. So there's really no leg for the AG to stand on. And what is obviously a problem in terms of his understanding of the law is that he reads one article, part thereof, and does not understand that our law has both a historical and a contextual element. The historical element is to show, and you made reference to it, how in developing our democratic system, in 1980, we came to a situation where we said there are going to be local organs that are part of the democratic system, representing the people, And that could only mean representing the people who reside in those local areas. And our national registration system relating to that specifies that when you're doing registration, then you must verify the people live there as the basis for them voting there. So this does not interfere with them voting, it interferes with them where they vote. And so that's the historical evolution of our system. And this system has evolved now up to the point of constituencies, where we have constituency assemblymen who are supposed to represent the people who vote for them. And we can only determine that those people who are voting have a right to vote for them if we do some physical verification of the residency, and cannot simply say that if somebody turns up and they give an address, that person has a right to vote in that particular place. And in fact, our National Registration Act has provisions that can have some such a person charged if they give an address at which they do not live. So you see the holistic legal provisions says you have to be living where you are voting, because you are not just voting in a national election. You have instances you vote in a local election and you can't be alien to the area and vote. And now you're voting in a constituency election and you can't be alien to the constituency and vote. So clearly there is some motive that one could discern if the AG and the government seeks to institute a law that provides for people not to have to verify that they do belong in a particular place and to be able to go vote wherever they feel like, which in a sense provides for a manipulation of the voting roll so that you can have people go and vote in particular places to influence a particular result. And so permit me.
Yeah, before you go, the document I was looking at as well, the constitutional document I was looking at, shifted from Article 72 to 77. But I've found here the one.
173?
Wow, yeah. It said it was a repeal in 2000. 173 to 76. Articles 173 to 176 repealed by Act number 14 of 2000. So that's why it's not in that document.
Just one moment. Let me now, in the circumstance of that, go to Article 160. 160. And I also probably want to go to Article 164. 160. 160. And in Article 160, it is specified, Article 160, 3A says, subject to provisions of the Constitution, Parliament may make provisions for A, registration of electors, 2, for the manner in which lists of candidates shall be prepared, and 2, under 2, it refers to paragraph 4, and which manner shall allow voters to be sure that individuals they're electing to the National Assembly. The point I'm making here is that this provision says that the voters must be assured of who they're electing to the National Assembly, and this relates specifically to the new provision for constituencies. And if you allow people who don't belong to the constituency, then a voter cannot be assured of who he's electing to the National Assembly. So there is another provision that deals with that matter. I think we'll have to clarify this question of the absence of 173 at another occasion, because certainly you can't jump from 172 to 177.
No, well, it says it's been repealed.
But if it's repealed, the numbers would be would be rearranged
Well,
to have a free flow.
I suspect that why the document that you have may not have, because I was looking at that exact document here, and that did not offer an explanation. However, the actual parliamentary, the constitution document, which is on the parliamentary website, um, provides the information which I supplied. Um,
Suffice to say that the system still provides for, and there are legal sources to justify this, for specifies
yeah.
that you must be residing in a region if you're going to, in fact, to cast a vote. So let me go on to show what mischief is afoot.
Please.
We have local organs, constituencies in those organs, regions, and the nation at large. We have witnessed in local government elections that what the PPP has in fact done, where they have a local authority that undoubtedly they would win historically and by virtue of the nature of the population, they would normally take voters from that local authority into an adjacent or another local authority to register. They're not living in the other local authority, but they go in the register, they're given an address. So what this law is seeking to do is to remove the impediment that existed previously of them having to stay and physically identify with the place. So they go, they register, and then they go and they vote. And what the vote is doing, it is manipulating the voters list to give the PPP a majority in the area where they would not normally have a majority.
And the evidence is there, Mr.
And this occurred in the 2018 local government elections with specific reference to Fowles Buxton, where they known to have bought people from Myconi, an area that they would win. So whether the people don't vote there or not, it doesn't matter. Into Fowles Buxton, cast votes, and they won Fowles Buxton in the 2018 elections. That has been reversed in the most recent elections. In the national elections, the evidence is there. We have seen that there are Guyanese, overseas Guyanese, who have a right to participate because we have provisions for registration of non-resident Guyanese. But we have seen scores of people from Nigeria who do not have residence in quarantine, many of whom not even originally resided in quarantine. So when they left Guyana, they weren't living in quarantine. I'm told a lot of them came from Region 3. Brought back into quarantine during the registration process, given addresses, they then registered those addresses and returned to Nigeria. Now they're entitled to be registered. So I'm not questioning them being registered. But that you give them addresses in quarantine is an attempt to rebalance quarantine, because that's the place for which most of the PPP voters have migrated. And so the numbers are being decreased and they stand a chance of losing in local areas and in Berbice at large. So what they're doing is bringing these people in and having them registered there to rebalance the situation when they're not entitled under our laws to be registered there because they are not original residents or current residents of that area.
The same happened in the same election in Lethem, the municipality of Lethem, where persons from Mokomoko, outside of the boundaries, the geographic boundaries of the local authority area, were transported to vote because of the same arrangement. In addition to that, a number of persons who were residing in Brazil, in Bonfim and in other areas like Bovista and so on. They were registered to the extent that there was a case of more than 100 persons registered at the same address, which was an empty lot. Recently, the Village Voice published information regarding 110 persons registered at Ogle in one house.
Yes.
So the mischief afoot is being aided by what appears to me to be an attempt to manipulate the laws.
Well, the mischief here is, in the first instance, to dismantle the legal architecture that is there for our democratic system, and to dismantle that legal architecture because they want to facilitate the undemocratic practices which are what they're involved in. You know, Guyana is said to be a democracy. According to the PPP, we returned to democracy in 1992. The fact of the matter is that one may argue that we've always had problems with democracy because democracy has three pillars. Representation, and that's the one that's being dismantled now. Responsiveness, and that's the one that we don't really have, because the government is unresponsive to the population when they have problems. And responsible behavior, we also don't have that one, because that one is equivalent to transparency. Transparency not meaning what you could see. Transparency meaning that there's an equal application of the law to everyone. And the extent to which in Guyana, in a whole range of things, there isn't equal application of the law in circumstances, then the legs of democracy do not, in fact, exist in the totality. And here we are now seeing that what we reportedly returned to in 1992, electoral democracy, is now being dismantled because the whole system of representation in a representative system of democracy is being dismantled by the manipulation of who votes where, and therefore not allowing for the people of an area to determine their representatives, and not allowing for accountability of the elected people to the people who they are actually supposed to be representing. So what we're having is a furtherance of the dismantling of our system of democracy to give dominance and control in a very dictatorial manner in terms of how we administer the affairs of the country.
We are in a serious crisis, well, a series of crises in this country. There's discrimination. There is ethnic discrimination, and there's political discrimination. There's victimization and persecution of persons considered to be critical of or opponents of the government, of the governing party. There's corruption. There's the famous Sugate, and that was the opening of the floodgates for corruption to flow. We know about entertainers being given contracts to build a school that without experience, and we know that the school is perhaps 2 years overdue. We recently had a situation where the United States Secretary of State complained bitterly about our concussion highway. Those contractors were all local contractors, friends, families, and favorites of the People's Progressive Party, and not, as the esteemed Secretary of State said, not Chinese contractors. And contrary again to what the learned gentleman said, it was not the previous administration, but the current sitting administration that is responsible for those roads. But corruption nonetheless. There is manipulation at the level of oversight mechanisms. The Public Accounts Committee, the Auditor General's Office not looking into critical areas that require reporting. The failure of the Parliamentary Sectoral Committee on Natural Resources to meet when the chairmanship resides with the People's Progressive Party. The Border Committee of the Parliament not meeting, the Foreign Affairs Committee of the Parliament not being convened, the President not briefing the people of the country with respect to matters as important as the territorial controversy between Guyana and Venezuela. All of these things affect national life.
Mervyn, you've excluded a big one that is provided for in the Constitution. We talk in the Constitution about the inclusionary democracy, inclusion. And we have a system where the president has clearly said to this nation that he doesn't have time to go and talk to local democratic councils, neighborhood councils. He specifically told the people in Mocha Arcadia that I've come to talk to y'all. I don't have time to talk to your representatives.
That is correct.
Clearly undermining the democratic system.
And a direct violation of Article 9.
Direct violation of Article 9 and other articles in relation to inclusion. But Mervyn, let me go back to completing the answer to the question you asked about the conduct of the Attorney General. You know, in court, the Attorney General said to the judge, we are fortunate that we are in this court because I don't know what would happen in other courts and how other judges would behave on this matter.
That we didn't include Carol Smith Joseph.
No, he said we the representative, he and his government. And he was speaking to Justice George, speaking about her being a good judge, and therefore the fortunateness of being in front of her for this matter. And you know, the irony of the fact is that Justice George is the judge that they refused to appoint as the Chief Justice. So she's worthy and good when he's appealing to her for a decision. But she's not worthy and good to be the Chief Justice of this country. In that court, he also sought to berate GCOM's lawyer. That these people don't know the law, and it's unbelievable that they would make in these arguments. He should be pointing the thumb to himself, because he is the one who, in my view, is misrepresenting what our law provides for. Our law clearly provides for what should happen in local government elections, what should happen in regional elections, and that was what was being argued by the GCOM lawyer.
But what is interesting here is that I am not accustomed to hearing stories. In fact, I've never heard a story of a lawyer berating another lawyer in open court.
Oh, he berated the lawyer.
And so for the Attorney General to do that suggests that he is, like the drowning man, seeking to clutch to any straw that he can.
Well, some of the straws he was clutching to weren't in the court, in terms of the court system, because the Chief Justice said to him, you've made that point already, you don't need to repeat it. And he said, he clearly said to her, I'm not speaking to you. Physically turned and used the court, he said, to speak to the press. So what he was on a political excursion in the court, not speaking to the judge, berating a lawyer and not responding to the lawyer's arguments necessarily, but berating the lawyer, berating other judges by saying that he's fortunate because he's not knowing what will happen in before other judges, and then telling the judge that no, allow me to speak because I'm speaking to the press. Press members were there.
Sounds like an abuse of the authority of the office.
Completely, in the political excursion. And then referring to the matter, he went on to tell the press subsequently that this is not a legal matter. This is the People's National Congress and the APNU having a political agenda. When in fact, what is clear, not only from the case he's arguing, but what they're doing in the fields, clearly demonstrate that they're pursuing a political agenda and trying to use the legal system to pursue it, and that political agenda adds up to dismantling our architecture for democracy, which would restrict their practices, which are anti-democratic practices.
I started out by listing a few things there, and your addition of the sidelining, the ignoring of local authority areas and their elected representative by the president in violation of Article 9, among others. What seems to be the only construct of democracy left in Guyana is the democracy of numbers at elections, and how we accomplish clean numbers, reliable numbers, transparent and acceptable numbers that determine free, fair, and credible elections seem now to be a victim of the People's Progressive Party's operations through no less a person than the Attorney General himself. What is left of our democracy?
Not much is left, and that is why they don't want biometrics, specifically the identification of voters by virtue of their fingerprints at the place of poll, because that will authenticate our numbers. In the absence of that, there's a lot of leakage and seepage in our voting system. And that is why they have not in any way done anything to ensure that the dead, particularly those who are overseas, are not taken off of our poll, because that is the gateway for fraudulent and duplicate voting. We have tens of thousands of Guyanese who are overseas, and more particularly, large numbers of Guyanese in the thousands who have died overseas, whose names are on our voters' roll and are not being taken off because there's no mechanism to take them off. They're not on the roll.
And they may have addresses.
They may have addresses because they were registered in the past. Some of them were verified when they were registered. We now have a situation where they're not going to be verified. But these names remain in the roll, and then we see the evidence from the recount that these people were voted for. So it is dismantling the architecture for our democracy to facilitate the corrupt practices that have been perpetuated, all of which dismantles the democratic systems in Guyana.
What is responsible for the deferral of the judge's ruling from last Friday to this week?
Well, the judge had initially indicated she would have ruled on Friday,
yes,
but subsequently the judge herself unearthed a ruling that had not been given because the case had been withdrawn, and she thought she wanted the counsels of both sides to speak to that ruling, and so she shared it with them, and then came to the court and indicated that she had prepared a ruling on the matter at hand, but that she would not deliver the ruling before hearing if the counsels had any oral submissions on the case she had shared with them. And in that regard, the GCOM counsel and the AG did have oral submissions. I think oral submissions which she now has to take into consideration. And on that basis, she deferred the ruling, which she said she had already prepared.
Last Friday, the Attorney General caused additional submissions to be made in writing. My understanding was that that aspect of the proceedings had been closed when the judge named the date for ruling last Friday.
Correct.
But not last Thursday.
For Friday.
Yeah. Could you advise the viewing public whether or not the further submissions filed by the Attorney General were actually included in the matter going forward?
It is unclear to me. Suffice to say the following. She came She made no reference to those submissions and said she had a decision. She went on to say that she's going to hold her decision because she wanted the councils to speak to a previous decision that she had circulated after she said she would give a ruling on Friday. That's what she said. The Attorney General did say to her, I made a subsequent submission. Her only response was, I received it. She did not say whether she received it, whether she, and acted upon or took it into consideration. She did not say that.
Were the other parties given an opportunity to respond to those submissions, or did they benefit from service thereof? And perhaps if they were not required to respond, it may not have been considered.
From the little that I saw, I think they may have benefited from, because I think he sent it to them. So but for example, the counsel for the Carol Smith did not speak to that. And my own recollection is the counsel for GCOM did not speak to that either.
Right, so that seems to settle the issue of whether it was or would be used in the matter. Because I found it extremely strange that after everything, there's closure to all of that. And from what I've learned, there's no leave of the court to file such further submissions. I found it very strange.
Well, Mervyn, a lot of strange things happened. One of the strange things that happened was the court met on the Monday. Submissions were made. Oral submissions were made on the Monday. Written submissions had been previously made. GCOM met on Tuesday, and there was no discussion on this matter, period, in GCOM. Monday, the court met. GCOM met on Tuesday. GCOM met on Thursday, and there was no discussion on this matter on Thursday. But the same Thursday came these releases. What's interesting about the releases is that we, the public, first saw the release on a GCOM CEO's letterhead on the AG's page.
Yeah, many people believe that the drafting seemed to have had the fingerprint of the AG.
Well, that's possible. But what I'm saying is that clearly, even before GCOM sent out the release, which was subsequently sent out on a GCOM letterhead, as is normal, on the AG's page, the release was there on GCOM's letterhead, which meant on the CEO's letterhead, which meant that the CEO obviously was in touch with the AG. Might be for drafting purposes, I don't know, or for signing purposes, but it is clear he was in touch and shared that with the AG even before GCOM itself made the release. And this is very, very evident by the way in which what he shared was shared by the AG, apparently post haste on his Facebook, even before GCOM itself had made it public.
Do you believe that the statement under the hand of this chief elections officer was an attempt to appeal to the court of public opinion, having recognized that the High Court was a lost cause?
Undoubtedly, it was an attempt to appeal to the court of public opinion. I would not like to be preemptive about the High Court. So undoubtedly, it was an appeal to public opinion. But more than that, I think it was also an appeal to the court itself. Because that would have been in the public domain. And it meant that the judge may have been exposed to that. And in the world of psychology, which is a part of American jurisprudence, the fairest of judges could be impacted by any material on the matter that comes to his or her knowledge. So I'm not questioning the judge's fairness, but I'm saying the judge is a human being. And American psychology speaks to how do you influence this human being. And I'm saying that any information that we have come to the judge's attention outside of what took place in the court could affect the judge's subconscious and therefore impact
in terms of an appeal to the court, it appears as though it was the statement that was used in an attempt to pave the way for the subsequently filed further submissions.
No, because the subsequently filed submissions came before.
Came before the
And
statement?
yes, came before came before the statement. But the interesting part of that is this, that the statement sought to speak, as you correctly said, to the public. And the statement sought to speak to the public only after news source reported on the case. So the public did not have information prior to that on this matter. But once information became available in the public through news source, we saw the appeal of the AG to the public. So news sources said one thing, let me say my thing, so that the public court does not rely on what news sources said, but it has what I am going to say.
Interesting. In summary, Mr. Alexander, would you agree with the suggestion that Guyana's democracy is essentially, as it stands, dismantled by the People's Progressive Party?
I would say that we have always had a problem as a democracy, and that there has been attempts historically to put in place representative democracy. But the People's Progressive Party's contention is that democracy returned in 1992, and my position is that that contention can only relate to representative democracy, because we've had problems as a colony with the other elements of democracy. And our political culture has not quite embraced democratic practices. That 1992, there was a contention that we were returning to democracy, which could only be electoral or representative element of democracy. And that there were things in our constitutional arrangements, local democracy, regional democracy, constituencies that sought to enhance the architecture for democracy. There are always issues with the practice, but these things sought to enhance the architecture so we could then build a real democracy. But this architecture is now being dismantled as the practice has never really conformed with the provisions for democracy.
The product of elections as you outlined it, are vehicles to guaranteed electoral democracy. The product of electoral democracy, particularly at the local level, and by that I mean from the RDC going right down to the last local democratic organ, has been upturned by the People's Progressive Party, the product, the outcome, so that what the Local Democratic Organs Act and associated legislations provide for, as far as representative democracy is concerned, as far as participatory democracy is concerned, and I speak to people's involvement in the decision-making with respect to issues that affect their well-being, as is constitutionally provided for, all upturned by the People's Progressive Party. I don't have time to speak with NDCs says the president. The Minister of Local Government making determination with respect to how money is spent and what is done, and overriding decisions made by the municipality of Georgetown.
Overriding provisions of the legislation.
Precisely so. All of that is being done as a normal practice by the People's Progressive Party. It seems to me, Mr. Alexander, that representative democracy has already been dismantled.
Let me respond to you this way, in very short terms. The People's Progressive Party at its last Congress removed from its constitution its adherence to Marxism-Leninism, but it retained democratic centralism. The fact of the matter is democratic centralism has to be juxtaposed to Western and liberal democratic system. They're not the same. Democratic centralism is not a representative democratic system. The PPP has retained democratic centralism and practices it by virtue of the conduct of political affairs manifest in the way in which the General Secretary of the People's Progressive Party operates. He speaks on behalf of the party, on behalf of government.
With no line separating.
No separation. We have imposed upon us a system of democratic centralism. And in that regard, almost a virtual admission that we're not a liberal democracy. And what the PPP is seeking to do is to have democratic centralism prevail by the way in which they're now dismantling the legal architecture that could provide for a liberal democratic system.
Ladies and gentlemen, democracy in Guyana is in crisis. Democracy in Guyana is under threat. Democracy in Guyana is being progressively dismantled by the People's Progressive Party. We have an opportunity, which will come our way shortly, to remove the People's Progressive Party from government and reclaim and reposition and reinvigorate the democratic principles, the democratic architecture, and the products of those processes in this country by electing a new government led by the People's National Congress Reform. That's all we have time for today on Nation Watch, and I'd like to thank you, Mr. Alexander, for joining me here and providing the information and clarity that you did.
You're most welcome. Thank you.
That's all we have time for. Until we meet again next Sunday, God bless you all.